Madam Chair, this isn't just about one faulty algorithm, Congresswoman Crockett began, her voice steady but cutting through the noise of the packed hearing room. Cameras clicked, aides whispered, and every word she spoke seemed to hang in the air. It's about how technology is quietly rewriting the rules of democracy without anyone voting on it. A murmur rippled across the chamber. Just months earlier, a federal court ruling on a discriminatory voter verification algorithm had set off a chain reaction no one saw coming. Within days, 3 states announced internal audits to uncover hidden bias in their election software. The National Association of Secretaries of State rushed to form a task force on algorithmic transparency, determined to prove they could police themselves before Congress did it for them. Now, Crockett, once an attorney fighting in the trenches, sat as a lawmaker, no longer cross-examining witnesses, but shaping the next chapter of civil rights law. Our system hasn't kept up, she continued, looking directly at the panel. These codes are making decisions about who votes and who doesn't. And our discovery rules were written for paper trails, not data trails. Her words hit harder than any headline. Law schools began taking notes, literally. Within months, courses appeared at top institutions teaching algorithmic justice and civil rights advocacy. Professors used what became known as the Crockett case to train future lawyers on how to read technical audits, demand access to code and discovery, and recognize when discrimination hides behind math. Civil rights groups, too, began to evolve. The NAACP Legal Defense Fund created an algorithmic justice initiative, hiring data scientists alongside lawyers. For the first time, litigation teams included coders who could trace bias in system design before it reached the courtroom. The old playbook was being rewritten, line by line, by people who understood that racism could be automated as easily as it was once written into law. Months later, Crockett reflected on the turning point in an interview. Technical systems are deciding who gets housing, who gets jobs, who gets justice, and who gets to vote. If we don't understand how they work, we can't protect people from their consequences. Her conviction wasn't born of theory, but of hard experience. The night she'd watched an entire election map glitch out because an algorithm flagged thousands of legitimate voters as unverified. Even Judge Howell, who had presided over that fateful case, later spoke with rare humility. At a judicial conference on technology, she admitted, "Our courts must approach code with the same scrutiny we bring to any human witness. Complexity cannot be an excuse for impunity." 1 year after that landmark hearing, the transformation was visible everywhere. Law schools training hybrid experts, courts updating their evidence standards, and states re-examining their digital systems with a new sense of accountability. What began as a single courtroom fight had evolved into a movement, one where law and technology finally stood on the same side of justice. And for Congresswoman Crockett, that was the real victory, not a verdict, but a vision. Madam Chair, this isn't just about one faulty algorithm, Congresswoman Crockett began, her voice steady but cutting through the noise of the packed hearing room. Cameras clicked, aides whispered, and every word she spoke seemed to hang in the air. It's about how technology is quietly rewriting the rules of democracy without anyone voting on it. A murmur rippled across the chamber. Just months earlier, a federal court ruling on a discriminatory voter verification algorithm had set off a chain reaction no one saw coming. Within days, 3 states announced internal audits to uncover hidden bias in their election software. The National Association of Secretaries of State rushed to form a task force on algorithmic transparency, determined to prove they could police themselves before Congress did it for them. Now, Crockett, once an attorney fighting in the trenches, sat as a lawmaker, no longer cross-examining witnesses, but shaping the next chapter of civil rights law. Our system hasn't kept up, she continued, looking directly at the panel. These codes are making decisions about who votes and who doesn't. And our discovery rules were written for paper trails, not data trails. Her words hit harder than any headline. Law schools began taking notes, literally. Within months, courses appeared at top institutions teaching algorithmic justice and civil rights advocacy. Professors used what became known as the Crockett case to train future lawyers on how to read technical audits, demand access to code and discovery, and recognize when discrimination hides behind math. Civil rights groups, too, began to evolve. The NAACP Legal Defense Fund created an algorithmic justice initiative, hiring data scientists alongside lawyers. For the first time, litigation teams included coders who could trace bias in system design before it reached the courtroom. The old playbook was being rewritten, line by line, by people who understood that racism could be automated as easily as it was once written into law. Months later, Crockett reflected on the turning point in an interview. Technical systems are deciding who gets housing, who gets jobs, who gets justice, and who gets to vote. If we don't understand how they work, we can't protect people from their consequences. Her conviction wasn't born of theory, but of hard experience. The night she'd watched an entire election map glitch out because an algorithm flagged thousands of legitimate voters as unverified. Even Judge Howell, who had presided over that fateful case, later spoke with rare humility. At a judicial conference on technology, she admitted, "Our courts must approach code with the same scrutiny we bring to any human witness. Complexity cannot be an excuse for impunity." 1 year after that landmark hearing, the transformation was visible everywhere. Law schools training hybrid experts, courts updating their evidence standards, and states re-examining their digital systems with a new sense of accountability. What began as a single courtroom fight had evolved into a movement, one where law and technology finally stood on the same side of justice. And for Congresswoman Crockett, that was the real victory, not a verdict, but a vision. And inside those same calls, Your Honor, Crockett continued, we found variables labeled race_group and ethnic_flag that suggest these categories were directly factored into the voter purge algorithm. Judge Howell's head lifted slightly, her earlier impatience giving way to intrigue. Those labels are notable, she said carefully. But variable names alone don't tell us how the system functioned. Developers use shorthand, placeholders, sometimes even jokes. You can't draw conclusions from that. Crockett didn't push back. Instead, she leaned into the judge's reasoning. You're absolutely right, Your Honor. Labels alone don't prove discrimination. But we also analyzed the purge logs. They show that 83.6% of the voters flagged for removal came from census blocks where minority residents make up less than a quarter of the state's population. That kind of imbalance doesn't happen by chance. It made us look deeper. A low murmur rolled through the gallery. The room was packed, civil rights advocates, election officials, law students scribbling furiously, journalists whispering into recorders. The tension was thick enough to taste. Judge Howell folded her hands. Statistical disparities don't automatically prove bias, Congresswoman. There could be valid explanations for those numbers. Crockett nodded. Exactly, Your Honor. And that's why we're asking for the missing modules. Without seeing how those weighting factors were applied, we can't determine whether this disparity reflects legitimate data inputs or unlawful bias built into the system. That was when DOJ Attorney Sarah Jenkins stood abruptly. Your Honor, she said, voice sharp. The government has produced every document required by law. The claim that there are missing modules is pure conjecture. There's no evidence for it. Judge Howell inclined her head slightly, considering. Ms. Jenkins makes a fair point, she said. Congresswoman, you're asking this court to compel the release of materials the government insists do not exist or are irrelevant. That's an extraordinary request. What solid evidence do you have that their certification is incomplete? The room went still. Every eye turned to Crockett. She spoke evenly, every syllable deliberate. Your Honor, we believe the government's certification, while perhaps not intentionally misleading, is incomplete. The words hung in the air like a live wire. Suggesting that the Department of Justice had failed to fully comply with discovery was perilous. Howell's eyes narrowed. Congresswoman, that borders on accusing federal attorneys of deceiving this court. Do you intend to make that accusation? I'm not accusing anyone of bad faith, Crockett said calmly. But the evidence we've uncovered shows a gap between what the government says exists and what the public record confirms. That gap is material and cannot be ignored. Judge Howell's tone sharpened. And what exactly is this evidence? Crockett held the moment, letting the anticipation build before replying. 3 independent indicators, Your Honor. First, the unexplained references in the code we've already discussed. Second, a Freedom of Information Act response from another federal agency that explicitly references the demographic_weight_module, the same one missing from the government's production. And third, she paused, emails between system developers discussing plans to move demographic weighting data into a separate module for compliance reasons. Gasps broke out in the gallery. The judge's expression changed. Her voice lowered but gained weight. You have written correspondence confirming a deliberate separation of demographic data from the primary algorithm? Yes, Your Honor, Crockett replied. Why? The judge asked slowly. Was that not presented in your earlier filings? Because we obtained them yesterday through a state public records request, Crockett said. They weren't included in the government's discovery production, even though they clearly fall under our original request. Jenkins shot up again. Your Honor, the government has no knowledge of these so-called emails. Without seeing them, we can't verify their authenticity or context. Judge Howell turned back toward Crockett. Do you have those emails with you right now, Congresswoman? Crockett reached into her briefcase, her hand steady. Yes, Your Honor, she said, sliding a thick folder onto the table. And I believe they speak for themselves. The courtroom erupted in whispers as Howell gestured for the clerk to collect the evidence. For the first time that day, the judge's authority gave way to curiosity, a rare, unmistakable shift from control to contemplation. And as Crockett watched her argument land, she knew this was the turning point, the moment when the fight for digital accountability crossed from speculation into undeniable proof. Crockett hesitated before handing the folder to the clerk. Your Honor, she said evenly, before I submit these, I want to be clear. Our purpose isn't to cast blame or embarrass the Department of Justice. We simply want to ensure that all algorithmic components relevant to this case are fully disclosed. Judge Howell exhaled, her patience wearing thin. Understood. Let's see the emails, Counselor. Crockett didn't move right away. Instead, she met the judge's gaze. Before I do, Your Honor, she continued, her tone calm but deliberate. You should know these records indicate something far more serious than oversight. According to the communications, certain modules were intentionally withheld from discovery, not only in this case, but in others, specifically to prevent scrutiny of how demographic data affected voter purge decisions. For a fraction of a second, the courtroom froze. Then Judge Howell let out a sharp, unexpected laugh. It echoed off the wood-paneled walls, brief, incredulous, and utterly out of character. Counselor, the judge said, a smirk crossing her face. That sounds like a conspiracy theory. The Department of Justice doesn't hide evidence. That's what discovery rules are for. Her tone dripped with disbelief. It was meant to end the conversation. But Crockett didn't waver. Understood, Your Honor, she said calmly. Then I'll let Exhibit C speak for itself. She opened her briefcase and drew out a manila folder, its edges creased from use. Handing it to the clerk, she returned to her seat without another word. Judge Howell began to read. At first, nothing. The faint hum of the courtroom's air vents filled the silence. Then, slowly, the smirk faded from the judge's face. Her eyes narrowed. She flipped another page. Then another. Her brows knit tighter with each turn. The atmosphere shifted. Every whisper vanished. Even the journalists stopped typing. Within minutes, the once dismissive judge looked up sharply, her expression unrecognizable. Ms. Jenkins, she said, voice taut. Are you familiar with these communications? The DOJ attorney blinked, clearly thrown off. No, Your Honor. As I mentioned earlier, we have no knowledge of any such emails. The judge's tone dropped to something colder, graver. These appear to be internal messages between system developers and legal counsel. They explicitly discuss, and I quote, segregating demographic weighting factors into separate modules not subject to standard discovery. Gasps rippled through the courtroom. Judge Howell turned another page, reading aloud again. Here, this one refers to maintaining technical deniability about something called the race correlation algorithm. She paused. That's not a phrase one forgets. Jenkins's face had gone pale. Your Honor, this is the first I've seen of any such language. The department would never authorize. Ms. Jenkins, the judge interrupted, her voice slicing clean through the explanation. I understand you personally may not have known, but these emails were sent from government domains. Several recipients are attorneys within your own department. The DOJ attorney sat down slowly, her expression stunned. Judge Howell shifted her attention back to Crockett. The energy in the room felt different now, no longer adversarial, but deeply serious. Congresswoman, how exactly did you obtain these? Through a public records request to the state's Information Technology Division, Crockett answered. They were released yesterday. It appears the state's personnel didn't realize these were excluded from the federal discovery set. Howell's expression hardened. She lifted another page from the folder and read silently for several seconds. Whatever she saw there deepened the lines on her face. Finally, she set the papers down, the sound loud in the quiet chamber. The earlier laughter was gone, replaced by something else entirely, disbelief edged with fury. "Counsel," she said softly, almost to herself, "it seems we may be dealing with more than a missing document." No one moved. No one spoke. The weight of the moment settled over the room like gravity itself, an unspoken understanding that something much larger than a single case had just cracked open before their eyes. "This email," Judge Howell said slowly, flipping to the third page, "refers to creating, let me read this correctly, alternate documentation for litigation purposes, omitting any mention of the demographic correlator." Her tone carried a quiet astonishment. She looked up, meeting Crockett's eyes. "Congresswoman, are you suggesting that this so-called alternate documentation is what was produced to you in discovery?" "Yes, Your Honor," Crockett replied without hesitation. "The file checksums in these emails match the discovery files we received. But those checksums don't match the technical specifications referenced elsewhere in the correspondence. That's how we confirmed a substitution occurred." A hush fell over the courtroom. Judge Howell slowly removed her glasses, a gesture every seasoned attorney in Washington recognized. When the judge took off her glasses, it meant something serious had just shifted. She set the papers down with deliberate care. "This court will recess for 15 minutes, she said, her voice low but firm. "Ms. Jenkins, contact your supervisors immediately. Congresswoman Crockett, please prepare authenticated copies for the record." The gavel struck once, but the sound seemed to echo far longer than usual. As Judge Howell stood, the atmosphere cracked open. The laughter, the smirk, the dismissiveness, all gone. In its place was something heavier, the unmistakable realization that the government's integrity might be on trial as much as the algorithm itself. When court resumed, the tone was transformed. The judge's words came out measured, deliberate, carrying the weight of institutional gravity. "Based on my preliminary review of Exhibit C," Howell began, "I have serious concerns about the completeness of the government's discovery production. These communications appear to show the deliberate omission of key technical materials central to the plaintiff's discrimination claims." Her gaze locked on the DOJ attorney. "Ms. Jenkins, I understand you've conferred with your supervisors. What is the government's position on these documents?" Jenkins rose slowly, her hands trembling slightly as she adjusted the microphone. "Your Honor, the department takes these allegations extremely seriously. We've initiated an internal review to determine how such emails could have been omitted. Until that review is complete, we cannot speak to their authenticity or provide context." "That's not sufficient, counsel," Howell snapped. "These messages don't suggest a clerical error. They suggest intentional concealment. Does the government dispute the authenticity of these emails? Yes or no?" Jenkins hesitated. "At this time, we can neither confirm nor deny." The judge cut her off, her voice suddenly sharp. "I'm not asking for a full internal review, Ms. Jenkins. I'm asking whether you have any immediate basis to dispute the authenticity of emails sent to and from government domains, between government attorneys and system developers. Do you?" The silence was suffocating. Then, quietly, Jenkins answered, "No immediate basis, Your Honor." "Then this court will proceed on the presumption that these emails are authentic unless proven otherwise," Howell declared, her tone resolute. The room stirred, the weight of her ruling sinking in. Turning back to Crockett, she asked, "Congresswoman, what relief do you seek in light of these revelations?" Crockett stood, her posture calm but her voice resolute. "Your Honor, we request 3 specific remedies. First, immediate production of all technical modules mentioned in these emails, including the demographic correlator and any linked components. Second, authorization to depose every individual named in the correspondence so we can trace how these algorithms were structured and deployed. And third, given the clear attempt to withhold critical evidence, We asked the court to appoint an independent technical expert to conduct a full forensic review of the system for potential discriminatory bias. Judge Howell studied her for a long moment, the faintest flicker of respect crossing her face. "Those requests," she said finally, "appear reasonable under the circumstances." She turned back toward Jenkins, who stood rigidly at the government's table, her knuckles white. "Ms. Jenkins, do you require time to respond?" "Yes, Your Honor," Jenkins managed, her voice barely steady. "Very well," Howell replied, closing the folder before her. "But make no mistake, this court expects full candor and complete cooperation moving forward. If even one document was withheld intentionally, the consequences will extend far beyond this case." As the judge rose once more, the courtroom remained utterly still. The echo of her warning lingered in the air, a reminder that beneath the veneer of bureaucracy, the fight for truth was still alive, and that one determined woman had just forced the system to look straight into its own reflection. "The department requests 14 days to investigate and prepare a response," the government attorney said carefully, her voice tight. Judge Howell didn't even try to hide her displeasure. 14 days, she repeated, her tone sharp. "Absolutely not. The government will have 3 business days to confirm the existence of these modules and begin producing them. And as for the independent expert, I'm granting that motion right now." Her words fell like a gavel strike before the gavel even came down. The judge leaned forward, her eyes sweeping across both tables. "Let me be clear. This court treats discovery obligations as sacred. If evidence has been deliberately withheld, there will be consequences, serious ones, not just for individuals, but for every office involved." Then, almost imperceptibly, her tone softened as she turned to the Congresswoman. "Ms. Crockett," she said, "your diligence has served this court well. Your technical command and persistence have exposed what appears to be a grave procedural failure. Without your efforts, this issue might never have come to light." It was a moment of visible reversal. Only an hour earlier, Howell had laughed at Crockett's claim, brushing it off as improbable. Now she was commending her in open court, her tone full of measured respect. The room felt electric, like history was tilting on its axis in real time. What began as a simple discovery dispute had transformed into something far larger, a public reckoning with how technology intersects with justice, and how easily transparency can vanish behind complex code and legal formalities. By the next morning, the story had already spread beyond the courtroom. Judge Howell issued a formal written order that did more than summarize her rulings, it amplified them. The order confirmed the immediate appointment of Dr. Elena Chun, a nationally recognized computer scientist and expert in algorithmic bias, as the court's independent technical examiner. All communications connected to the voter verification system were to be preserved in full, and a special evidentiary hearing was scheduled to investigate the alleged discovery misconduct. But what drew the most attention was a single paragraph buried midway through the order, one that would echo across law schools and policy circles. The court notes that, but for counsel's technical expertise and persistent inquiry, the concealment of algorithmic components may have succeeded, thereby undermining the plaintiff's ability to establish their claims regardless of their validity. That statement, clear, restrained, and devastating, set off shockwaves across the legal community. Within 24 hours, the National Law Journal published a feature titled, "When Code Meets the Constitution: How a Congresswoman Exposed Algorithmic Concealment." Editorials followed in rapid succession, debating whether the justice system was equipped to handle the hidden biases buried in software that shaped public policy. Law professors began rewriting their syllabi overnight. Technology and law clinics cited Crockett's confrontation as a turning point, calling it a masterclass in digital-era civil rights advocacy. Meanwhile, pressure built inside the Department of Justice. The following week, the DOJ announced an internal review to determine how the concealed modules had escaped disclosure. The Inspector General launched a parallel investigation into all active voting rights cases, scrutinizing whether similar omissions had occurred. Several senior attorneys were quietly placed under administrative review, while the Civil Rights Division issued a new guidance memo, one that fundamentally reshaped federal discovery obligations in tech-related cases. All components of any system used for voter roll maintenance, the memo declared, must be disclosed in full, including all modules, source code, or analytic tools that process demographic or correlating data, regardless of their classification or nomenclature. For many, it was the first time the government had publicly acknowledged that algorithms could conceal discrimination just as effectively as any human could. And at the center of it all stood Congresswoman Jasmine Crockett, once dismissed with a laugh, now hailed as the woman who forced the justice system to see what it had long overlooked. That fairness, in the age of algorithms, required more than faith in procedure. It required vigilance, courage, and the will to question even the code itself. Stanford law professor Jennifer Martinez reflected on the unfolding case with precision. This moment exposes how traditional discovery tools often collapse when technology enters the equation. Algorithms can be built to obscure bias behind layers of neutral code. Without technical literacy, justice risks being blind to digital discrimination. 2 weeks later, Dr. Elena Chun delivered her preliminary expert report. While most of it remained sealed for confidentiality, the court released a carefully worded public summary. The findings were explosive. Dr. Chun confirmed exactly what Congresswoman Jasmine Crockett had feared from the start. The system's so-called demographic uncorrelated module wasn't neutral at all. Beneath its sterile name, the code contained weighting factors that disproportionately flagged minority voters for removal. Her analysis revealed that the algorithm assigned higher purge scores to individuals whose names reflected specific ethnic origins and to voters who had changed addresses between predominantly minority neighborhoods. None of these variables were labeled by race. Yet, in effect, they functioned as precise racial proxies. What appeared to be a neutral technical filter was, in practice, a digital sieve shaped by bias. The implications were massive. What began months earlier as a procedural battle over withheld discovery had evolved into direct, substantive proof of algorithmic discrimination, the kind that could redefine how civil rights law is enforced in the digital age. Within days, Judge Beryl Howell issued an emergency injunction halting the entire voter verification program. She also ordered that every voter wrongfully removed under the system be immediately reinstated. Her written opinion left no room for ambiguity. As correctly identified by plaintiff's counsel, the algorithmic architecture intentionally separates neutral-seeming processes from concealed modules that deploy proxy variables tied to race and ethnicity. This structure appears designed not merely to mask the system's disparate impact, but to obscure its discriminatory intent. It was a seismic ruling, and one that would echo far beyond that marble courtroom. On the day of that decision, the District Court of Columbia's courtroom was overflowing. Reporters filled every bench, their pens poised, while legal observers leaned forward, holding their breath. The air carried a strange tension, the faint echo of a laugh that, only weeks earlier, had dismissed everything now proven true. That laugh belonged to Judge Howell herself. Only a short time ago, she had leaned back on the bench, eyebrows raised, amusement flickering in her eyes. "Counselor," she had said to Crockett, her voice laced with disbelief. "That sounds dangerously close to a conspiracy theory. The government doesn't hide evidence. Discovery rules exist for a reason." The courtroom had chuckled softly, following her lead. The message was unmistakable. Crockett's claim was not just implausible, it was absurd. But Jasmine Crockett hadn't flinched. She didn't argue, didn't raise her voice. Instead, she reached calmly into her leather briefcase, withdrew a single manila folder, and held it steady before the clerk. "Your Honor," she said evenly, "I'd like to submit Exhibit C." The room seemed to tilt. Judge Howell accepted the folder with faint irritation, but as she began to read, her composure cracked. Her smile disappeared, replaced by something taut and uncertain. She flipped through the pages quickly, then slower, then stopped entirely. A long silence filled the chamber. Then, without a word, Howell set the papers down, adjusted her glasses, and said, "The court will take a 15-minute recess." She rose and left the bench, her steps brisk but unsteady. That moment, the laughter giving way to shock, became the turning point of the case, the instant when skepticism collided with evidence so undeniable it shattered disbelief itself. When proceedings resumed, the judge's tone had transformed. Gone was the dismissive edge. In its place was gravity and respect. What followed was a series of rulings that not only vindicated Crockett, but fundamentally reshaped how courts approached algorithms in government systems. The headlines came fast. The Code That Lied: How a Congresswoman Exposed the Hidden Bias in America's Voting Systems. Editorials called it a wake-up call for the digital age. Legal scholars compared it to landmark moments in civil rights jurisprudence. But this time, the battleground wasn't a lunch counter or a polling booth. It was a line of code. And at the center of it all stood Jasmine Crockett. Calm, resolute, the woman who had turned a courtroom laugh into a national reckoning. Before you see what was hidden inside that folder, and how one piece of evidence changed everything, make sure you hit the subscribe button and turn on notifications, because this story proves one thing: truth has a way of resurfacing, even in the digital shadows. We bring you stories from the courtroom that most media outlets never show you. Moments where law, technology, and democracy collide, and the outcome could determine whose voices count in America. The case before Judge Beryl Howell wasn't just another legal proceeding. It was a fight over the very foundation of the right to vote, a challenge to a statewide voter purge that civil rights advocates warned could silence tens of thousands of citizens, many from minority communities. The lawsuit alleged that the state's automated system, an algorithm-driven purge program, was quietly removing legitimate voters using criteria that appeared neutral on the surface but were, in effect, racially skewed. State officials denied every accusation, insisting the algorithm followed lawful data matching standards designed only to maintain accurate voter rolls. The system doesn't see race, one state attorney said bluntly in an earlier hearing. It sees only numbers and records. The Department of Justice backed the state's position, telling the court that there was no credible evidence of racial bias or intent. But the plaintiffs, a coalition of voting rights groups, saw it differently. To them, the issue wasn't whether the code said race. It was whether the code acted like it did. Presiding over it all was Judge Beryl Howell, a jurist whose presence could fill a courtroom before she even spoke. Appointed to the federal bench by President Obama in 2010, Howell went on to serve as chief judge of the U.S. District Court for the District of Columbia, one of the most consequential courts in the nation. Her resume was formidable: former federal prosecutor, Senate Judiciary Committee counsel, and a specialist in digital forensics and complex evidence. She was admired and feared in equal measure. Lawyers who appeared before her knew the rules: come prepared, stay factual, and never bluff. Howell's courtroom was a place where speculation died and precision survived. Her reputation wasn't partisan. Even critics described her as fair but unsparing. She could cut through grandstanding with a single raised eyebrow. When Judge Howell spoke, juries listened, and lawyers reconsidered their next sentence. That day, her courtroom was packed. On one side sat the government lawyers, calm and confident, backed by the full weight of the Department of Justice. On the other stood Congresswoman Jasmine Crockett, and she brought with her a presence that rivaled the judge's own. Before serving in Congress, representing Texas's 30th District, Crockett was one of the fiercest civil rights attorneys in the South. She'd made her name not by shouting louder, but by mastering the language of evidence, algorithms, statistical models, predictive coding, and data audits. While most lawyers shied away from technical discovery, Crockett dove into it, fluent in both the law and the math behind injustice. When she announced she would personally argue this case, pro bono, it made national headlines. Some critics accused her of blurring the lines between legislator and litigator. Supporters, however, saw her move as the embodiment of public service. If democracy is under threat, one voter said in an interview, "I want someone like her fighting for it, in Congress and in court." That morning, she stood at the plaintiff's table surrounded by boxes of files and a single laptop covered in yellow sticky notes. Across the aisle, the state's lead counsel whispered something to the DOJ's representative, both smiling slightly, as if the day's outcome were already written. The central issue wasn't ideology, it was access. Crockett's motion to compel sought the full algorithmic code, all log files, and any technical modules tied to the voter purge system. Without that data, she argued, there was no way to prove whether bias existed in how the algorithm scored voters for removal. The algorithm, she told the court, isn't a black box, it's a mirror. And if it reflects our nation's oldest prejudices, we have a constitutional duty to see what's inside. The government disagreed sharply. Their attorneys insisted every relevant document had already been turned over. They accused the plaintiffs of fishing for code that didn't exist, a digital wild goose chase. Judge Howell leaned back in her chair, eyes narrowed. "Congresswoman Crockett," she said, her tone deliberate and cool, "what you're asking for goes beyond normal discovery. These are proprietary modules, sensitive election infrastructure. What proof do you have that something relevant was withheld?" Crockett didn't flinch. "Proof, Your Honor, is exactly what we're seeking. But what we already have is enough to raise serious questions, including variable names and log patterns that suggest demographic indicators were used in the system's calculations." The judge's brow lifted slightly. "Suggest," she repeated. "Not proof. Yet," Crockett said simply. The courtroom stirred. At that moment, it became clear this wasn't a routine discovery fight. It was a test of how democracy would survive in the age of code. And while the nation's cameras weren't yet rolling, everyone inside that federal courtroom knew one thing. This case was about to decide not just what data the government must share, but what truths it can no longer hide. Before we go further, what do you think? Should states be required to make their voting algorithms public? Are current systems transparent enough to ensure both election security and equal access? Drop your thoughts in the comments. Your voice matters in this conversation about America's democracy.